It's Grant Abbott from I Love SMSF, and welcome to all my strategists and also our family SMSF advisor members. This is an exclusive and a VIP session where, although you know that I've written this book, we're not going to go into this book because this book is set at a level of what we call, when we look at training standards under the ASQA, which is the Australian Skills Qualifying Authority, which is set at a level of AQF 5 or 6, which is most of the general training in the industry if you go to an SMSF association event, etc. So we're not at that level because you guys are strategists and you're also your family SMSF advisors. So our core competency is to be able to read, understand and apply the law. So for that I'm putting the book away. In fact, I'll just throw it over there. And what we do is we're going to look at the big book, which is our Bible really, which is the Australian Superannuation legislation. If you haven't got this book, in Molly Meldrum's words, do yourself a favour and go and get the book. It's the Australian Superannuation legislation 2018. I'll continually refer to this when we go down and do our face-to-face sessions such as this, and particularly if you come along to one of our breakfast sessions, and certainly make sure if you've got the possibility of coming along you do that, because we're going to get down and dirty into this. Well, this takes us to a level of AQF 8 and 9, which is set at a master's level. In fact, with our 4-day Family SMSF Advisor accreditation course, we're looking at getting a master's status in that one. So it's the next level up. So we're going to look at that. And the session today that I thought I'd look at, because an article came out the other day on a case, it was a New South Wales Court of Appeals decision, Cam and Bear versus McGoldrick. And we'll put that up on the site there for you. There's a couple of cases there. One was in the Supreme Court, and then this was a recent decision to the Court of Appeal about the original decision. So it's extremely recent. It was only done in May, and here we are in July. Very, very scary, and I'm going to go through that. I also then want to take you into the SIS Act, because if you're worried about this, once we start hitting the SIS Act, things actually get a lot worse. So there's two things that I can give to you as takeaways. I'll just put the book down. First off, is that in your professional life, particularly when you're dealing with self-managed super funds, you're dealing with fairly big ticket items. For clients, they're not losing like $5,000, $10,000, $15,000. They're losing $200,000, $300,000, $400,000, in some instances $1 million or $1.5 million. You'll see, for example, the damages awarded under Irving and Dunstan under Section 55(3) was $380,000 against an accountant who'd given poor advice. In the case here for McGoldrick, who was an auditor, they're still assessing the damages, but it'll be in the vicinity of all losses, and 90% of the losses are to be attributed to the auditor McGoldrick, and that will be in the vicinity of a $300,000 plus. So once we start looking at this, they're quite significant. We can find that even from there, we can go, if we're making a profit out of this, is that we can end up with imprisonment for up to 5 years. These are the two areas that we want to focus in on, and as I said, the two issues that we really want to look at is, firstly, in your own dealings, wherever possible, make sure you get really good strong sign-off in terms of what you're doing. Particularly when it comes around to investments, understanding that your client or your trustee of your SMSF really understands what they're getting into. And that's what happened in the McGoldrick case. They thought they were getting a cash investment in Lewis Securities, but in fact was an unsecured loan. And McGoldrick never actually made an assessment or determination of what that underlying investment in LSL Securities was. As a consequence of that, Cam and Bear, Mr. Bear, who was it was a medical practitioner who had given his money to Lewis Securities, really wasn't aware. He thought it was in cash, but it was in fact in an unsecured loan. And of course, when Lewis Securities collapsed, went into administration, he ended up losing quite a significant amount. And of course, wasn't going to challenge Lewis Securities, and ended up attacking the auditor. As you would expect, in fact, it had an extremely good legal counsel on this one. And unfortunately, the McGoldrick's lawyers, McGoldrick's going to have to pay for the lawyers as well. Anyway, the main thing is we want to make sure that we've got a really tight ship our documentation is perfect, and that we make notes in relation to our clients, because that was the key issues that came out of this. We need to show that we're very good witnesses, and more importantly, the experts that are brought up can really have no fault with our process or our determination. On the flip side is that we also want to make sure that when we do get clients, and you will, particularly if you're a family SMSF advisor, you're going to start getting SMSF clients coming from accountants, administrators, financial planners, and you're going to see there's been losses occasioned in some way, shape or form. What we need to do there is not dwell on those losses, but, and when I mean not dwell on them, not to sort of get the client in an emotional state where they're just thinking about the loss, but actually put in place an action plan. As an advisor, putting in place an action plan to recover the losses, which is now, if you ask me, is now quite easy under negligence, under section 55218, under the Australian Financial Complaints Authority. You can get up to $500,000 there. Not necessarily section 201 we want to keep away from there, but that's certainly when we're negotiating around that, it's certainly a great card to pull out of the pocket. When we want to do that is, if you do come with clients with losses, is to sit down and work out and say, well, hold on, contact TGA Legal, myself or Tony Anamoulis at TGA Legal, work out if we've got a case. Because if we do get a case and we're using 55218, or AFCA, we can move it through very, very quickly and recover damages quickly, as opposed to, of course, the negligence action, which could take 3 or 4 years to go through the courts. We start there, we then move there, but we throw everything at everyone, particularly the auditors, the accountants. And now that we've got some standards around auditors, that if there's been any breach by the accountant or the auditor, they haven't done their job, then they're going to fall into 55. So let's just go back and have a look at the instances. First off is in this negligence action, I told you there, we had Cam and Bear, who were the trustees. It's a Cam and Bear Proprietary Limited, trustees of their family superannuation fund. They took action against McGoldrick, who was the auditor. They didn't take action against the administrator. They didn't take action against Lewis Securities, mainly because at that point in time they were in administration. So it was really, you can add them to the claim, but look, if they haven't got any money, they haven't got any money, it's not worth it. So you look for the person who's got the money, and more importantly, the PI. When it went to the Supreme Court looked through the action and the Civil Liability Act in New South Wales, and they were going through a negligence action. When we had a look at what McGoldrick did, he didn't make an assessment. In fact, he never even talked to the trustee, which is pretty typical of many auditors. Didn't go in and assess that on the balance sheet of the fund where it had cash, that it was an unsecured loan to Lewis Securities Limited, which was a subsidiary of Lewis Securities. And as a consequence of that, when Lewis Securities fell, they've lost all their money. Now, the original instance, the judge held that McGoldrick, really the underlying reasoning behind the loss was the relationship between Lewis and Bear. Bear being the medical practitioner and Lewis being the securities advisor. Because of that trusted relationship, Bear gave all the money, all his money, his contributions and all that to Lewis to effectively invest in what he believed were shares and, more importantly, cash, because he wanted to go to cash in 2007. What transpired from there, though, is that the original Supreme Court decision held that McGoldrick was only around about 22%. So McGoldrick was, in fact, liable, but then contributory negligence came in, and it was around about 22.5% that McGoldrick was liable. On appeal to the Court of Appeal, and I believe that they were making a statement here, is that particularly in relation to self-managed super funds and the importance of the audit role here, is that 90% of the negligence, or 98% of the losses, were actually attributed to Goldrick. Again, this is only a new case. It's raising huge shockwaves in the industry in terms of how auditors and accountants, planners, and everyone could get caught. Now, mind you, and I'll move from here to section 55 and 218, but before I go there, this obviously applies now. It's a long drawn out process. If you're going to take a Supreme Court action negligence, you're looking around about $50,000 to $100,000 in legal fees. But certainly from this case, really most clients have got a fairly successful claim, I would believe. So it's the opposition or the accountant, the auditor, who are really going to have to pick up costs, which is a little bit scary. In between there, and I'll just put this here, AFCA, and I'm only not discussing this because this doesn't come in till the 1st of November 2018. Importantly, that big change that is going along in terms of the Australian Financial Complaints Authority is anyone who is licensed or caught under the SIS Act is now covered by AFCA. Previously, before, we had 3 different systems. We had one looking after credit, we had one looking after the Super Complaints Tribunal, and of course the Financial Services Ombudsman. That's now all been consolidated into one body where consumers, and in this case we're looking at trustees of self-managed super funds, are able to make a claim against advice provided to them, and it's a no-cost basis. So unlike before where it used to cost to make a claim under the Super Complaints Tribunal, now there's absolutely no cost basis. So really, if anyone's made any loss on any investment or whatever, it's worthwhile putting a claim into AFCA. People don't understand it yet, but certainly that'll come down the track. Importantly, under the old Super Complaints Tribunal legislation, you couldn't be a vexatious litigant. That is, there was awards against that, or there was a precursor that you couldn't be a vexatious, which is like taking a vexatious litigant is simply someone who's trying to get back an advisor by filing an action that may have no merit. There is no such thing under AFCA. You can be a vexatious litigant. So clients who disaffected with you can effectively file any sort of complaint there. The important thing about that is, particularly around self-managed superannuation funds, and if there's a breach of the SIS Act, what we can get there is up to $500,000. So that's an award of up to $500,000 to recover losses. I would say with both here and here, and also to a lesser extent here, where experts will be drawn upon in terms of the liability in the action is going to be fairly important. Certainly from my perspective, I can see myself and TGA Legal getting involved there at the expert level, but certainly they're going to be looking at experts in terms of AFCA. And the last thing you'd want is me on the other side saying what an expert SMSF advisor should be, seeing that I wrote all the standards in terms of providing advice in self-managed superannuation funds. So AFCA, watch out for that, $500,000 award. You've got your significant negligence action, which is now obviously worried about. Section 55 and 218. 55 is much the same. I'm going to go to the legislation. For those of you who've got the big book, you might well just want to turn to page, and this is exactly how we go through things when I do my course. I'm on page 210 of the superannuation legislation to 2018. Basically, it says there's section 55, and we can understand this pretty easy. Section 55(1), a person must not contravene a covenant contained in or taken to be contained in the governing rules of a superannuation fund. So, for example, we might have a covenant under our, and when we look at our superannuation rules, for example, a covenant might be that is brought in that a minimum pension payment must be made if we effectively have an account-based pension. Now, the problem about that is that if we don't meet that minimum payment, then there's a whole lot of consequences arise. First off, we lose the tax exemption in terms of that particular year, and that can create problems. The other one is potentially if the covenant says you must take a minimum pension payment, you don't, then it means that that pension is commuted and it's rolled back to the accumulation side, and that has a whole lot of TBA, has a lot of tax-free taxable components. There's a lot of issues around that. So there's quite potentially a lot of losses that are attracted to the fact that a minimum pension is not made during a year. Now, the consequence of that is that once we quantify those losses, then any person, if we have a look at section 55(1), who has been involved in that action. For example, if the auditor doesn't pick it up, or if the accountant or the administrator is not aware of it, or hasn't been following it up to the 30th of June to make sure minimum payments are made, potentially they're getting caught under Section 55. Now, unlike the negligence issue, where there can be contributory negligence, here there is no contributory negligence. Any person who's caught that has breached the minimum payment rule is effectively caught in there. So that would be the actuary, but more importantly, probably the administrator or the accountant involved in this case, or the financial planner. In Irving and Dunstan's quite an interesting case there, is that Dunstan was a member of a self-managed superannuation fund and wanted to draw out his balance of $1.6 million. It was $1.53 million. Irving, who was the other trustee and much younger member of the fund, said that he wasn't entitled to withdraw the money because there was a bit of a fight around the underlying premise of how there was an allocation of investment income and capital gains in that fund. Now, anyway, the long and short of it was that the court went through, and it was the New South Wales Supreme Court went through and said, look, the assessment that Dunstan should have been paid out, the $1.53 million, was appropriate. It should have been paid out under the governing rules of the fund, because that was what was required. It had to be paid out within 60 days. Because it wasn't taken out at that stage, by the time it got to the Supreme Court, it was 20 months down the track that there were damages under Section 55(3). Because if we go down and we can find that there's a breach, and here there was clearly a breach in Irving and Dunstan because the money should have been paid out, or Dunstan should have been able to withdraw his money from the fund. We then go down to 55(3), and 55(3) says, subject to subsection 4A, a person who suffers loss or damage, Dunstan in this case, or our member who didn't get their minimum pension amount, a person who suffers loss or damage as a result of the conduct of another person that was engaged in contravention of subsection 1 may recover the amount of loss or damage by action against that other person or against any person involved in the contravention. Against any person involved in the contravention. So here in Dunstan's case, they took action against Irving, but could quite easily have taken action against any other person. But Irving is the one who prevented that money coming out. Now, over the big issue there is Dunstan obviously got his $1.53 million, but then the court had to come around in 55(3) and determine the quantum of losses. What they did is they came in and they brought an expert witness out, said, okay, if Dunstan had pulled the money out and put it in his own self-managed super fund, what portfolio would he have had? A conservative, an aggressive, or a balanced portfolio? And on a balanced portfolio for that 20-month period, obviously the markets were doing well, he should have earned $380,000. So $380,000 was awarded against Irving as trustee of the fund and payable to Dunstan under Section 55(3). Likewise, we see the same case. If the minimum payment wasn't made, then quite clearly there's been a breach, probably by the accountant, maybe the auditor, certainly the planner. And again, this is not contributory negligence, it's the fact that someone has breached. If you can ping someone on a breach, then you're caught. And it's 100%, not 90% as we've got here in negligence. As a consequence of that, we have to determine under 55(3) what the liability is. To give you even a more extreme example, one of the covenants that is contained under Section 52B of the SIS Act is that the trustee of the fund must put in place an investment strategy. You know, it looks at risks, cash reserves, so on and so forth. Now, what would happen is currently under modern administration practice, and to me it's extremely dangerous, is that usually these investment strategies are pumped out by an administrator maybe 6 to 9 months after year end and said, please sign this is the investment strategy. That is not investment strategy. In fact, there's commissioners' rulings saying that's not investment strategy. So investment strategy should be done now on the 1st of July, or ratified now on 1st of July for the following year, and then we invest according to that. The problem is if there is not an investment strategy, then it means all investments have to be in line with the investment strategy. If not, then you've breached Section 52B and obviously the governing rules of the fund. So if there's an investment and there is no investment strategy because it's given at a later stage, and that's a very easy argument to pull, you don't even need an expert because you've got the Commissioner's guidelines on that, then what we do is we work out the quantum of the losses. So someone, for example, might put in place, they've put contributions in, they've invested in stocks, GFC comes in, wipes out 40% of the value of the stocks, there is no investment strategy, then they'll be able to take action against the auditor and also the accountant for full recovery of those losses. So extremely painful scenario, but something for all of us to be aware and come to TGA legal again if there's a particular issue around that. Section 218 is much the same sort of thing, as that at any point in time an action may be taken by the member or the trustee to recover losses. The same thing if there's been a breach of the SIS Act, then you can claim losses or damages against any person involved in it. It's strict liability, it's not negligence. We don't have to show that there's contributory negligence. If you're caught, then you fall within there. And particularly under the new NALI provisions, the non-arm's length income, we've got to be really very careful about that. Now the final one is section 201. And I'll leave this one because this is fairly instructive about why, and certainly I would say that after this case here, McGoldrick, who really was not coerced, but was given 70 funds to be audited by, and they really had no experience as a SMSF. In fact, they went to Lewis Securities, McGoldrick did, to set up a self-managed super fund, and then Lewis, the proprietor of Lewis Securities, said, well, why don't you audit all of my funds? So it looked to me as though McGoldrick was, and sorry if you're watching this, Mr. McGoldrick, it looked as though you were a bit of a patsy in the whole scheme of things. But anyway, it's cost you, unfortunately, very dearly. So we've got to be extremely careful about how we deal and conduct our practice. Again, one of the reasons why I'm a great believer in doing family SMSFs is that you're only looking after 40 or 50 clients maximum, and you're really making sure everything is perfect. Anyway, is section 201. In fact, it's not section 201, I stand corrected. So again, you see what happens when you don't go to your legislation first. So that's a fairly good example of someone pretending to be unconsciously competent when they're in fact only consciously competent in terms of the criminal proceedings. So section 202 says, if a person contravenes a civil penalty provision, which would be Goldrick actually breached his auditor's provisions, AFCA, Irving, or Duns Irving did in this instance, or the auditor or the accountant, remember the minimum pension payment, either dishonestly and intending to gain, whether directly or indirectly, an advantage for that or another person, or intending to deceive or defraud someone, the person commits an offence punishable on conviction by imprisonment for not longer than 5 years. So I did get the imprisonment for 5 years right, just had the one section wrong. So we've got to be very careful about that one, whether the tax office would take that action, but certainly they have taken that action in a number of cases. They use section 202 for that, where people go for the early release. They put a number of people in jail for that. So that spectrum there is really more the tax office. From here on in, we're looking there is an action that can be taken from a member's perspective or trustee's perspective, and particularly with you in hand. If you see any loss, if you're worried about any loss, make sure you come to TGA Legal. If someone is taking an action against you, come to TGA Legal, and just be very careful to make sure that you keep your knowledge level up to the accredited standard. Because if you're much like McGoldrick, you don't know what you don't know, and you don't meet the relevant standards of being able to read, understand and apply the law, when it comes to being cross-examined or an expert witness points out what is required in court, you're going to fall pretty quickly. And as soon as you fall pretty quickly, that's where all of these start to apply. In fact, most of the cases we've taken to TGA Legal, it really doesn't even get to court because of the strict liability provisions here. Anyway, it's not a downer. This is more of a semi-uplifting session. Is just be careful of what you do. This is what happens as things can go wrong. But more importantly, if you see a client coming to you and there's an issue there, or you're worried about a particular issue, make sure you come and see us at TGA Legal. You can get to us pretty easily. Just TGA Legal. You can contact Tony, so Tanamoulis, T-A-N-A-M-O-U-R-L-I-S, Tanamoulis at tgalegal.com.au. Anyway, it's Grant Abbott signing off for our strategists and also our family SMSF advisor members. Make sure you contact us if any of these even start to touch you at all.